something that should be viewed for what it is. It is a delaying tactic. Each and every South African should know that the president has got a say in the appointment of judges and other senior counsels in the country. And others act for him and others act against him. If I can make a comparison, if the vote Kate Hofmeyr won, would he then said there's a conflict of interest for Kate Hofmeyr simply because Kate Hofmeyr has represented the president on a number of issues? So the problem here that we're facing a problem of a president that does not want to be held accountable in terms of Section 89 of the Constitution. That is a real crisis here. And I do want to spell out, Chair, that this is not the last time. Each and every process he is going to try and delay, frustrate, and somewhat prohibit the committee from fulfilling its constitutional obligations. This will be done or is done by someone who claims to be pro-constitution, respects the rule of law, respects Parliament's obligation, and functioning in holding him accountable. The first thing, therefore, from my side, is that we took a decision to appoint Advocate Madonsela as an evidence leader. And when we took that decision, all that the president is raising was declared by Advocate Madonsela. That's the first thing. The second thing is that before we decided on the evidence leaders, we had a long meeting where we defined what constitutes conflict of interest. And none of the matters raised by the president constitute then the conflict of interest. Therefore, it is something that should not be accepted when now the president is introducing his own version of a conflict of interest outside the parameters that were set by the committee. And if the president was really genuine about assisting the process, the minute we defined the conflict of interest, he would have had some input even then to say what then is, conflict of interest. So, but he did not do so. So what we're most likely to happen, most likely to see, is that we're going to see a process whereby each and every process is going to wait for a decision to be taken. And when the consequence of the decision is taken, which is progress, he's then going to try find some means of wanting to stall the process, of wanting to delay the process. Having said that, Chair, my suggestion is that let us move on with the work of Parliament. It can't be that now we're going to be coached, we are going to be dictated to by someone who we are holding accountable. Because in the entire process, he's interdicted the public hearings aspect of the process. Now he wants to somewhat stop the process of appointing an evidence leader. What next should we expect from him? So it's very important for South Africans to know that here we're dealing with someone who claims to have acted innocently and has done nothing wrong in relation to the matter at hand, but practically he's fighting tooth and nail, he's doing applying every trick in the book to try and stop the process from continuing. A process, by the way, that would enable him to clear his name, a process that would enable him to state his truth so that this matter can be put to bed. So, Chair, let us not allow to be delayed by the president. We must not be delayed by the very same ANC who should have raised this objection the minute the nomination was done. Not wait up until a decision is taken and then want to raise some form of objections. So echoing the colleagues' sentiments, please protect this process from frivolous delays that seek to frustrate the work of Parliament. Thank you.
Thank you very much, Honorable Motwe. Thank you, Chair. Greetings to yourself, greetings to the colleagues and everybody on the platform. I'm greatly covered by majority of the members of this committee, Chair. Chair, my problem is just one, is that you are treating this matter in isolation of the correspondence that you had received. Because one of the correspondences, the letters you received, is a letter from the ANC SG saying exactly the same thing that the president is saying. And the president is not saying anything different from what Advocate Madonsela declared to us. If you remember, legal came to present a document that Advocate Madonsela penned down after the nomination was made, where all these things that the president is saying were duly declared. So this is not a new matter. And in as much as the agenda says the feedback in relation to the appointment of the evidence leader, but we are going to go to the correspondence, and one of the correspondences speaks about this exactly. So these issues are intertwined, and they come from ANC, because President Ramaphosa didn't fall from the sky to be the president of the country. He came through a ticket of the ANC to be a member of parliament and then duly elected in an assembly that elected the president. And therefore, in as much as he's the president of the republic, but he's the president of the ANC, in and out of parliament, he remains the president of the ANC. And the SG of the ANC, having written this letter, with the knowledge that he has members in this committee who comes from the ANC, who did not raise these issues when these matters were being debated. So, and if they did, they were defeated. One, the ANC was defeated inside this meeting in a democratic process. And then the SG writes to us and say, he respects the decision, but these are the matters. But those matters, we assist with them prior to us making that decision. And then on the eve of this meeting, then the president comes and pens down an objection to this committee. So we're proceeding, Chair. There's nothing that legal office is looking into. If we are all fair, we're proceeding. What was being raised has been there. And Chair, the ANC, the president, those are the same things, including the members of ANC who are in this committee, because they took the mandate from the ANC. And if they failed to convince all of us that we should not vote for Advocate Madonsela, it's their problem. It's not our problem. They chose to abstain, and we respected their choice. And the choice of the majority was that Advocate Madonsela must be our evidence leader. And the case is closed. So we shouldn't reopen this matter for anything. Chair, I thank you.
Thank you very much, Honorable Hlophe.
Thank you very much. Good morning, Honorable Chair, and good morning to all honorable members who are on the platform. Chairperson, the ship has sailed. The ANC was represented at the last meeting when we appointed Advocate Madonsela. They lost the vote after the ANC elected. After the ANC participated in the process and abstained from voting, the result was that they lost the vote. I want to join previous speakers in saying, please, 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 you owe this, you owe us as a committee, you owe us as our chairperson. You must protect the integrity of this process. We cannot have a situation whereby President Ramaphosa, every time we want to move forward, and this very process could help him in terms of clearing his name, we can't have a situation whereby whenever we want to move forward, he puts more and more obstacles. He clearly doesn't want this work to continue at all. All I'm saying to you, Chairperson, I want to join those who are pleading with you. Please, please, please. The ship has sailed. The ANC lost the vote. The president participated through the ANC because the ANC, he is the president of the ANC. When Advocate Madonsela was nominated, he disclosed everything. And we had a long debate around what he disclosed. It does not constitute any conflict of interest at all. But also we must remember that the evidence leader does not decide. It is for the members of the impeachment committee who would be deciding on the strength of the evidence presented before them. It can't be that there is any conflict of interest on the part of Advocate Madonsela. The modus operandi, which has been followed by the ANC in respect of Advocate Madonsela, sadly, is exactly the same as the modus operandi that was followed in respect of Advocate Vuyani Ngalwana. We saw the ANC coming day in and day out with objections after objections. And this is clearly an attempt to discredit Black practitioners. We cannot allow this. A president who has nothing to hide should not be using all these delaying tactics. He's doing that in an attempt to avoid the inevitable. South Africans have a right to know what happened at Palapala. President Ramaphosa is delaying that. We cannot allow that. So I join those speakers who say the matter is closed, the ship has sailed, the ANC lost the debate, they participated by abstaining from voting. That in itself is a right to vote. Where you have to make a choice and you choose not to make a choice, that in itself is a choice. This is exactly what the ANC has done. There is absolutely nothing new in the correspondence, which was not raised before. We took a sound decision, knowing fully well what was disclosed did not constitute a conflict of interest. To sum it up, please let us carry on with our work. The objection by the president does not make sense at all. It does not constitute any conflict of interest, and there is no need for any other legal advice here. To advise us to do what? I rest my case, Mr. Chairperson. Please protect the integrity of this committee by allowing us to carry on with our work. I thank you, Chairperson.
Thank you very much, Honorable Vessels.
Thank you very much, Chairperson, and good morning. Chair, I agree that this issue, the objection raised by the President, is intertwined with the correspondence received from the ANC that is tabled and will be discussed later. But I don't think this issue can be discussed in isolation with that, because that raises something that I do not recall that was mentioned when we discussed and ultimately voted upon the nomination of Advocate Madonsela. I do not recall that that was declared. If I'm wrong, I apologize, but I do not recall that it was mentioned and declared that Advocate Madonsela was briefed by the ANC on the Section 89 extended rules, and that there was a consultation and work done in that regard. And that raises an issue for me that I think must be considered, as other speakers have also said, that we can't just not ventilate it. And at the time of the voting, if I'm correct that that was not disclosed at that stage, the voting occurred without the committee being aware of that matter. And that was not taken into consideration. Chair, and that is why I think, to protect the committee, a legal opinion on this matter would be the best option. I also agree with previous speakers that we should protect this process against any stalling tactics against Stalingrad strategies and so forth. And the inference can be made that this is a tactic to delay the process. But regardless of what the intention of the president's letter is, the fact of the matter is that there's something that can be raised later. And in a review application of whatever the outcome of this process will be, that issue can be raised and can be a hurdle. And protecting the committee against strategies of delaying tactics should also include protecting the process and making sure that there's no defect. And that is why, Chair, I would urge us to follow your proposal and get a thorough legal opinion on if that conflict is significant, and that we can make a sound decision and do our due diligence, because I don't believe that that fact was known to us when we made the nomination and voted on the matter, and it does change the scenario, and we must protect the committee not only from delaying tactics, but also from any defects in the process. Thank you.
Thank you very much. Honorable Mthambi.
Thank you so much, Chair, for the opportunity. The point that I want to bring home here, Chair, is that a democratic process must still in law be fair to affected persons. And then thanks for sharing the letter from the president with us, because reading the letter says nothing about who the president wants as evidence leader. But he's also raising some serious issues apart from these things that our colleague are saying, that the president is operating through the African National Congress. The president cannot participate through the African National Congress. He, like any other affected person in this process, has got a right to raise issues with the committee. And then doing so, then it means then he's trying to say to us, yes, I'm participating, but as a president, I'm entitled to a fair process. And if there's fairness, then the democratic outcomes are not a defense. At the very least, the letter by the president has to be considered for fairness, because if you look at paragraphs 4 and 5 of the letter, he's indicating, apart from the ANC letter, he's indicating some serious issues that relates to the conflict of interest, that relates to the removal of the proposed evidence leader from the JSC. And 5 is very specific and explicit that there is reasonable apprehension that the recommended candidate may harbor a sense of grievance towards the president, and then he may act upon it. So these are some of the issues that we need to seriously consider. That's why we are of the view that your proposal, Chair, must be supported. And we must emphasize this is not delaying the process. We are also mindful of the fact that the review will be held on the 3rd of September. At the same time, the Constitutional Court has ruled on this other direct access, and also respect that the other parties then have put an expedited appeal. So these are the issues that we are proposing, Chair, to say we must consider this a letter, and then once you do that, then there is no delay tactic. As I've indicated, the president also exercises his functions in terms of the constitution, same as us as parliamentary committees. We are exercising our separate function. Because the other issue, if we are going to consider the letter written by Honorable Daniels, we wouldn't have been here if we didn't do away with the issue about the vetting of evidence leader. because without us vetting all of them, it's inevitable that there will be gaps in information on those evidence leaders. So I should think also, as we consider the letter, we need to also consider Ms. Mallon's proposal, wherein he had indicated that we need to ask all the candidates to disclose every case they've had for or against the president, and we must do a proper vetting to make sure that the process is fair. So it's our own decision that I think we need to also to consider that decision that we do not do the vetting at all has opened all these doors for a problem like what we are currently encountering. But we'll support your proposal, Chair, under the circumstances. Thank you for the opportunity.
Thanks very much. Honorable Swart.
Chairperson, good morning, and good morning to the colleagues. Chairperson, I must say I do share the concerns expressed by the members that this is a wholly unsatisfactory state of affairs at this very late stage to have a letter of objection. You will recall that I referred to Rule 58 of the Legal Practice Council, which sets out the very strict boundaries on professional independence and deals with conflicts of interests. And my recollection is that the issue was touched on by our legal team of the advice that was given. I think the point is also very important that the evidence leader leads evidence. He does not adjudicate on the matter. That having been said, I am also aware that every step of this process is subject to litigation and review. So reluctantly, I do believe that we need to fully canvass this issue from a legal perspective, given the fact, if we err in this regard, and if there is a conflict of interest as set out, then a review application would, in all likelihood, succeed. So, Chair, reluctantly, and given the fact that this letter was only received last night, I tend to think we should allow our legal team on an urgent basis to advise us what are the legal implications of this. But I say this reluctantly. Thank you, Chairperson.
Thank you very much. Honorable Director.
Thank you, Chair. Greetings to our colleagues. Chair, the narrative that the president is deliberately delaying the process is not correct. The president has never said he doesn't want us to hold him accountable, but he's raising a concern about the fairness of the process with regard to the person who's going to be part of it. And Chair, the president, like any other citizen, has the right to raise a dispute where he believes that the process is not fair and is not in line with the rules, like he has indicated on the letter, and also mentioned some of the rules that he feels that the process are not in line with those rules. And therefore, it is also incorrect to subject his concern to the ones of the ANC, as this is a parliamentary process. So, Chair, also in terms of our draft terms of reference, it is clearly stating that the chief evidence leader must not have any real or perceived conflict of interest. So this is a requirement that we must apply as this committee. So therefore, Chair, as a result of this, I am in support of your proposal with regard to dealing with this matter. Thank you, Chair.
Thank you very much. Honorable Musa.
Thank you so much, Honorable Chair.
I
think we should think very, very carefully over our decisions, Honorable Chair and colleagues. I mean, there are two sides to integrity and the rights of any individual, whether it be a president or an individual, that must comply with being given a fair and equal opportunity to present any concerns, as in the case with the letter that has been received by our Honorable Chair. The president, like any other individual, is subject to the process, must be afforded a fair and reasonable opportunity to respond and present evidence. At the same time, the democratic process and the integrity of the vote must not be undermined without compelling legal and procedural grounds. Before the committee takes a final position, legal advice should be obtained on whether there are legitimate grounds to rescind, revisit, or otherwise interfere with the existing democratic decision. Honorable Dugmo's proposal to obtain legal advice is therefore a prudent and responsible approach, I think, from the committee's perspective. The objective should not be favor either the president or the opposing side, but to ensure that whatever decision is ultimately taken is lawful, procedurally fair, just, transparent, and defensible. Every person deserves the opportunity to place the evidence before the appropriate forum, but that right must operate within the rules governing the democratic process. Particularly, so we must not confuse fairness to an individual and favoritism towards an individual. Affording the president an opportunity to be heard strengthens rather than weakens the democratic process. So my appeal is that we, seek legal advice and given the opportunity, let's take advantage of this. Thank you so much, Honorable Chair.
Thank you very much. I want to
Chair,
check.
sorry, my hand is not a legacy hand. It is up again, if I beg your indulgence.
Is it an additional point, Honorable Ishbel Chawala?
Yes, sir, because you have shared the letter now in the group. I think there are two things that I want to raise. The first one is that the letter says the Secretary General of the ANC briefed the media on August 7 to tell the media or the citizens why ANC MPs in the impeachment committee abstained from the vote. I think I find that very unprocedural, and it smells of lack of trust. The ANC MPs couldn't tell us on the day why they're abstaining. They decided to abstain. They allowed the process to continue. And now that the process continued and successfully favors the Progressive Alliance, they are coming back to say, oh, we abstained because of this. It does not augur well. That's one. Two, it then fits in very neatly into the fact that the president is trying to decide who is going to be the evidence leader. Because if he is not trying to do so, I mean, this process is done and dusted. He would just allow the process to go on, especially because it means the ANC was sitting with this information. They knew before. It's not new. It's new to us that they are sending it last night to you, but it's not new to them. They already knew. No, Chair, I honestly, again, I appeal to your chairpersonship. I think South Africans are watching and looking at you and seeing what we are going to do. But it cannot be that GNU partners are in agreement with this here to open a vote that happened democratically. And they are arguing at us that no, the president is not trying to stall the process, or he's not trying to elect the person that he wants. He is, because the person was elected. And the two reasons he gave, that he briefed the ANC on matters relating to the impeachment committee, or that he removed him from the JSC, those things have got nothing to do with conflict of interest. So for me, honestly, Chair, I'm appealing. I think as the Progressive Alliance, I said this before, I think last month, that what do you want to do, GNU? Do you really want to run this process alone? I think let us know. Really, we can step aside as the Progressive Alliance and let the GNU run this process if that's what you want to do. But you can't come and give us stop and go all the time and undermine our intellect, and then come give us big legal and English phrases that no, he's not trying to, he has a right to. Of course he has a right to, but we have a right to find out what happened. The citizens have a right to find out what happened in a process that is allowed to go on without the interference of the GNU. Thank you, Chair.
Thank you. Honorable Ngitama, do you want to deposit a new point from the one that you deposited? I want to then be able to progress the item forward.
Yes, Chair. In light of being ambushed by the contents of the letter now shared in the group, it is clear that this matter has been brought before this committee also prematurely. And I do also want to reiterate the fact that this committee's integrity, it looks very bad at this stage. You are allowing, Chair, the President to determine how this process must unfold. It is very, very unfortunate. The matter has been closed, the matter has been voted for. What would be the basis for restarting and opening that matter? Chair, this is very, very concerning. Thank you.
Thank you very much, Honorable Ngutama, and thank you very much, honorable members, for your reflections. And I just need to make a few points so that I'm properly understood, also in terms of the proposal that I made. One is that the letter is received last night. There hasn't been a time to get proper advice on the implications of the letter, what are the options available to myself and also to the committee. So that's the first thing. So what I ask the committee is that we give space to the legal team to then be able to fully apply its mind. One of the worst mistakes that we can make as a committee is to believe that maybe the work that we do is beyond scrutiny. It is not. It is not. When matters of this nature are brought to myself as a chairperson, I have to fully apply my mind. And I don't feel that I have fully applied my mind and to just say, no, the committee has decided, therefore we are moving forward. I just want to remind members that we are here. The impeachment committee is here because the EFF had taken the decision of the National Assembly, which was, for those that were watching at the time, they will have said it's a democratic outcome to the Constitutional Court, and that matter brought us here. That decision of the National Assembly was set aside. The other instance that we have to consider, there was a decision when we started the 7th Parliament as it relates to the appointment of Honorable Hlophe to the JSC. The Democratic Alliance took that matter to court. Even though it was an outcome of a democratic process, that matter was the decision of the National Assembly was set aside. And the last example I want to give, honorable members, you might recall that the Standing Committee on Finance, on a matter as it relates to the VAT increase, had taken a decision by majority there, and it went to the National Assembly, and the National Assembly voted in majority. So the majority prevailed, but that particular matter was taken to court, and we know where we are right now. So to expect that from the chairperson, when there is such a development, one can respond by saying that the majority has voted, therefore I'm not going to fully apply my mind. It will be to expect that we just go as things are. I will not want to move in that direction. I've said that at all times we have to be guided by the law and consider all the options to ensure that the complaints around the stop-start that you are referring to, if there's an option that's available to the committee that will not lead to this matter going to court, then we must be able to consider that option. If this matter was to go to court, then we have to then say, all right, is that not a much prolonged delay on our side? And we can't just say, no, We voted last meeting, therefore the decision of the committee itself cannot be questioned. When there are matters of this nature, we have to fully apply our mind. And I don't feel that I have fully applied my mind, because the letter came through last night, and to expect that yourselves, you have fully applied your mind to this matter, it will be incorrect. So what I ask the committee is that legal applies its mind on this. So all the signatures that are required from Parliament side have been obtained. So from Parliament side, all the signatures have been obtained, but because there's this development, we cannot ignore it. If we ignore it, and then this matter is taken to court, then we'll be accused of not fully considering the contents of the communication from the president. So what I'm appealing to the committee is that we give legal the space to consider the options. And if they come and say, no, we have considered the options, we have looked at this, and when we believe that the committee is still within its correct, we can then proceed with the appointment. We will do so. But if they come with another option, then we have to consider it. But we will be failing in our responsibility as members of Parliament, as members of this committee, if we do not fully apply our mind to this. We have to take a step back from the politics of the matter and look at the legalities of the matter so that we can fully apply our mind to it. And at the moment, we haven't applied fully our mind to this, and we haven't been properly guided and be given advice. And what I'm appealing to the committee is that we give legal the space to look at the options available to us now that there's this development. My preference will be that this matter does not need to go to court. If there's an option that does not lead to this matter being taken to court, let it be explored. But for us to just say, all right, we have taken a decision last time we met, therefore we just ignore the contents of the letter from the president, I believe that will be failing in that regard. So that's the appeal, because I don't feel that, and the best way to protect the integrity of this process is also to be guided by the law and the legalities around this matter. So it was to be expected that every step of the way it's subject to being challenged. So if we see something that could be challenged, we need to apply our mind a lot deeper and be able to then proceed within the confines of the law. So the matter, it's not to say that Advocate Madonsela is not the one recommended. It's just to say there's this communication. How do we then move around it, and what are the options available to the committee? Once legal has come back with the options available to the committee, those options will be shared with the committee, and then only then can we then say we are proceeding. But for us to then take this letter, it's just been sent 14, 16 hours ago. So we haven't fully applied our mind to it. And I'm appealing, I've heard all the concerns from the members. I'm appealing that we give legal the space to apply its mind, to advise us on the options, and also for ourselves to apply our mind to this. And if we need to have a special meeting to just deal with this development, we will do so. And it's my wish that there be consensus on this matter. And obvious, in the absence of consensus, we'll then take the matter to a vote. But I'm appealing to all the members of the committee that let's apply our mind fully. This process itself, every step of the way will be challenged. So let's be alive to that possibility and fully apply our mind to this. So that's what I'm putting forward. I would prefer that we all agree to this, and if not, we will then take it to a vote so that we can be able to proceed on this matter. But I need to fully apply my mind on this particular matter. Honorable Chavala, Litfield Chavala.
Thank you, Chair. Yeah, I feel that we are being threatened now with a legal process. And again, you have shared this letter, we have read the letter. Two things are in that letter. That the president removed Advocate Madonsela from the JC so that he might have a grudge against him. He might, he's not sure, might have a grudge. I think that if I apply for a process or I apply for any opportunity and I don't get the opportunity, it was an application. It was going to go either way. I mean, I didn't get it. Does that now make me an enemy in the judiciary? Does that make me now for my participation in the judiciary to be limited because, oh, the president removed you, so we are not sure, you know, where you stand? And then the second one is that he had advised the ANC on the matter. And I heard that these things were not disclosed, but this was disclosed. So I'm not sure. So this letter that comes at the 14th hour, do you know how long ago we agreed on this vote, Chair? 14th hour, this letter comes. And this letter now is holding us all at ransom. It becomes a building block towards the legal challenge that could come our way in terms of the impeachment committee. And because this letter came and the SG of the ANC was quoted, we can reduce this to the parties. Everyone that spoke here that said the process should go on is in the majority. I mean, when I saw this, I even called the UDM and I said, you had voted for Advocate Madonsela. I know you tendered an apology, you are not in the meeting. Can we quote you as saying you want the process not to be reopened? You want the process to go on? They said, yes, please quote us. It was a democratic process that happened. It cannot be second guessed. So I'm trying to understand what's going on here, Chair. Are we being held at ransom because the ANC feels that way and its GNU partners are ganging up with it, and we are now being threatened about an ensuing court process if we continue? I'm trying to understand what is at stake here.
So just again to be clear, I'm not reopening any process. I'm saying we need to apply our mind. The letter came through 16 hours ago, and we haven't fully applied our mind that we can't disregard this communication. It doesn't matter what the decision that we'll have taken in the last meeting. If there's any development as it relates to the work of this committee, we should not be the committee that disregard that development based on the previous decision that we'll have taken. We have to take everything on board, consider it, and if we still say, all right, we have considered everything, but we're still proceeding, we need to do that. But let's not disregard the communication on account that the previous decision was taken. But if there's no consensus in the meeting, then I'll ask members to then indicate on the two options that I'll present to the members. Honorable Dagmo, you'll be the last one on this matter.
Thanks, Chair. Now, I want to respect your ruling that we don't go to the vote on this matter. And I think the arguments that you've raised are compelling. So we propose that we support your approach and that we close this matter. If colleagues want to vote, let's vote. But we propose that we accept your ruling and move on to the next item on the agenda. And thank you, Chair.
Honorable Musa, I had said that Honorable Dagmo is the last one. And then I will then be able to proceed. So thanks. Maybe let me check. Is there anyone that's against giving the space to the legal advice, legal services to fully study the contents and to provide the options that are available to the committee, so that when we take the decision, that decision is fully considered, and that we don't disregard the communication that we have received from the president. Honorable Chabalala, are you against that move?
Yes, I am, Chair. We can't get a legal opinion on something that was already known. So, yeah, as MKP, we are against it. We are saying it shouldn't even have happened. It shouldn't even have been brought here. So we don't agree with that legal opinion.
All right, you don't agree. Ngitama, the MKP has spoken. Are you disagreeing with the MKP? All right, thanks very much. So, honorable members, there seems to be two differing views in terms of how to proceed on this matter. The first one saying that we need to fully apply our mind to this communication that we have received from the president that has just been shared with the members. And the other one says that we need to continue without fully applying our mind. So I will ask the parties, as we had decided last meeting, the manner of voting. We are going to apply the same voting procedure that's applied in the National Assembly, wherein the parties will indicate the members that are in the meeting and the direction of Honorable Ngitama, unless if it's a point of order. So what is your
Yes,
end?
it's a point of order on you, Chair.
What is your point of order?
You are dividing the House on the basis of a wrong determination. You are saying that those who basically saying we must proceed without applying our minds on the matter, but we have seen the letter, we have read the letter, and we are objecting to it. So I don't know why you're saying those who saying we must proceed without applying our minds. I mean, you need a better phrasing of the division you are suggesting.
All right, thank you very much. So let's take it this way. Those who say that we need the legal advice on the letter from the president, and those that says that we don't need a legal advice on the letter from the president. I will assume that will be okay for you, Honorable Ngitama, in the so that the division is clear. Is that okay with you? That's better.
Sorry,
all right.
Point of clarity. Just clarity seeking question, Chair.
Yes, Honorable Ngoben.
What are we seeking from Parliamentary Legal Services? What advice are we seeking?
So the letter came through last night. They haven't studied the contents of the letter to provide advice to myself as the chairperson. So as things stand now, we need to be able to receive that advice on the options available to myself and the committee. And that's what I'm asking the committee to then say, let's give them a space so that they study the letter, advise the committee properly on the options available to the committee. Now that there's this letter, we can't disregard the letter. We can't.
I don't think anyone is saying we must disregard the letter, Chair. I'm just trying to understand what is the outcome that we are seeking. But yeah, so that we can vote accordingly. You are making options available to us for us to vote. So we also equally need to apply our minds as to how we are voting. That's why I'm asking the question. Thanks.
All right. Thank you very much. So those will be the options in terms of the communication from the president, the legal services to then give the options. Now that there's this letter, to give the options, and then the other one that we are voting on, the one that says that this communication should not be going to the legal services for options available to the chairperson and the committee. So we'll start with those that will vote. Will go with the parties according to the way that.
Point of order. Sorry. The second option is saying the matter should not go to the legal service because there is no conflict of interest. And number two, because it was already disclosed by Advocate Madonsela, the issue of the JSC. So yeah, complete the sentence. And also that this is information that was known to the ANC, which is the party that's objecting really. and its GNU partners are just agreeing with it.
All right. Thanks very much. So is the matter going to legal services for advice or not going to the legal services because the matter was disclosed? So we'll start with those that voting for the matter going to legal services so that they advise the committee. So we'll go in the order of strength of the parties. And they indicate if they support. If you don't support the option, just indicate the number of members from your party and indicate no. If you support, you then indicate the number of members in the call and say yes. So the first option is that the letter of the president be given to the legal services to offer advice and options available to the committee. Let's start. The ANC.
Thank you, Chair. The ANC supports that option of you as the Chair on our behalf asking for legal advice, and we do so with 9 members.
All right, thanks very much. The DA.
Thank you, Chair. Good morning. The DA votes in support of legal advice, and there are 4 of us on the platform.
Thanks very much. MKP.
MK Party, we are 3 on the platform. We vote against that. The letter by the president doesn't raise anything new. We vote against referring this to the legal team. Thank you.
Yeah, thank you. EFF.
Thank you, Chair. 2, myself and the president of the EFF are voting no legal services advice required.
Thank you very much. IFP.
Thank you, Honorable Chairperson. Greetings to the honorable members. The IFP vote in favor of taking this matter to get a legal opinion. Thank you.
Thank you very much. PA.
PA is not in attendance, Chair. They've submitted an apology.
Thank you very much. FF Plus.
Vote in support of legal advice.
Thank you very much. Action SA.
Thank you, Chair. We will support with 1 member. We don't think it's going to change anything. Thank you.
So are you voting yes, legal advice?
I said so. I said yes, legal advice.
All right, thanks very much. ACDP.
We support with 1 vote. Thank you, Chair.
Thanks very much. The UDM is not in the meeting. Bosa is not in the meeting, or is Bosa in the meeting?
Chairperson.
All right. There was an apology, Dr. Maiman.
I had sent the apology, but our meeting adjourned a little bit, so I thought I'll join the impeachment committee. And joining at this point, I want to endorse the view that says we need to get a legal opinion because the Stalingrad, whatever would happen, need to be legally settled up front so that we settle the matter once and for all. Otherwise, we'll go around in circles. So I support the view that we need to get a legal opinion.
All right, thank you very much. ATM. ATM.
The person, based on the participants, Mr. Zungula, I don't see him to be still in the meeting. Thank you.
All right, thank you very much. Al-Jama.
Thank you, Honorable Chair. Al-Jama votes in support of the legal framework for legal advice. Thank you so much, Honorable Chair.
All right, thanks very much. UAT.
UAT has apologized, Chair.
All right. NCC.
NCC, Chair, thank you. You know, as I have reported, Chair, they are still on suspension. Thank you.
Thanks very much. Thanks very much, honorable members. Temikos, if you could just do the count for me. No, before you do the count, I want to check, is there any member from the political parties who would like to vote differently from the vote that's expressed by their whip? All right, thanks. There's no one, and there's no abstentions. All right, thanks. Temgos, can you please do the count for me?
Thank you very much, Chairperson. In favor of legal opinion, 19, and against 5. Thank you, Chair.
All right, thanks very much, Temgosi. So the letter that we have received from the president that we received last night will then now be given to, so legal services has got the letter. They will apply their mind and provide myself as the chairperson, but also the committee with the options available given the issues that have been raised by the president. Thank you very much, honorable members. We'll now proceed to the tabling of contents. Just to indicate, members, it was a bit of debate on my side, given the new development, whether we should start with the tabling of contents or start with the update. But weighing the two, I believe that this was a serious development that we had to deal with first, and then those other issues in terms of that's there in the tabling of content and how we responded to them can then be dealt with. So it was a debate, and it was a last minute decision on my part, given that the letter arrived last night. Melissa, are you ready with the tabling of contents? Of correspondence, not contents, correspondence.
Good morning, Chairperson and honorable members. Yes, I am. I am just about to share my screen. All right. There was a letter received on the 7th of August. It was a letter from the ANC to the Speaker of the National Assembly. The letter was sent by Mr. Fikile Mbalula, who is the Secretary General of the ANC. The ANC states that it is making a voluntary disclosure of a prior professional relationship with Advocate Madonsela. The letter explicitly states that it is not an objection, complaint, or request for intervention, but rather information that Parliament should have before finalizing any appointment. Then there was a letter received on the 8th of August. The letter was from the Speaker to the Chairperson of the committee. The Speaker advises the committee on the correspondence from Mr. Fikile Mbalula. On the same day, a letter was received from Honorable Marlon Daniels, and it was addressed to the Chairperson and the Speaker. The letter was dated 5th of August, but was only received on the 8th of August. So Honorable Daniels raises extensive procedural, legal, financial, and impartiality concerns regarding the committee's decision to pursue constitutional court litigation and aspects of its ongoing work, and requests detailed explanations, disclosures, and safeguards to protect the legitimacy of the Section 89 inquiry. On the 11th of August, a letter from the Chairperson was received, and it was addressed to the Speaker. The Chairperson acknowledged receipt of the Speaker's letter from the 8th of August and advised that the matter will be tabled before the committee for consideration and discussion. On the 11th of August, the Chairperson sent a letter to Honorable Daniels. The Chairperson acknowledges receipt of Honorable Daniels' letter which was received on the 8th of August, the chairperson submitted that matters raised concerning decisions taken at the previous meeting may be raised as matters arising when the committee considers minutes of that meeting. Issues relating to the terms of reference may be raised when the item is tabled for correspondence at the next meeting, which would be today. However, because Honorable Daniels submitted an apology for today's meeting, and he will not be present, it will be considered in the next meeting where he will be present. On the 18th of August, which was last night, a letter from the presidency addressed to the Speaker, the Secretary of Parliament, and the chairperson was received, and this correspondence was addressed in the previous item in the meeting. Thank you.
Thank you very much, Melissa. Honorable members, those are the correspondence that we have received since the last meeting, and the two of the items related to the two of the letters related to the item that we just discussed. The one from Honorable Daniels, as it was indicated, responded that if there are decisions or discussions that have taken place in the meeting that you feel that maybe the decision was not correct and so forth, the opportunity, it's when we deliberate on the minutes, it can be raised there so that we can correct whatever issue you believe it was not properly dealt with. That's just the way that we would like to move forward. Can we note the correspondence received and the responses given? Honorable
Chairperson.
Thank you, Chair. As Chair, sizoba nenkinga la, truly. So whatever we do in this meeting, any of us has a right to write to the Speaker and say, no, I second guess whatever it is that happened. Honorable Daniels can't come to this committee and tell us, I don't agree with this. He must write to the Speaker, and then that issue must come back to us as a committee to entertain it. I think, can we take a principled decision here? Are we all working together here as the impeachment committee? I keep saying this, and I know that it's sounding like a broken record, but that's how we are operating right now. Are we an impeachment committee here of various political parties, but that are not party aligned, that are here to find the truth about what happened in Phala-Phala, and we are here as citizens primarily of this country and as elected representatives? Or are we sitting here as the GNU and the Progressive Alliance? Because it looks to me more and more like that's what's going on here. Honorable Daniels should stop this. And Chair, we should take a principled decision. We shouldn't allow it. Whatever it is that we have issues with the process or whatever, can we deliberate it here in this committee while we are all listening? We shouldn't have these back doors writing to the Speaker all the time. If we do that as the Progressive Alliance, will she listen to us if we write a letter to her, like Honorable Daniels has done? Thank you.
Thank you very much. Honorable Dagmo.
Thank you, Chair. Now, I agree that we should note the correspondence received and the correspondence then responded to by the Chair. But I do think I need to say that there's nothing stopping any member from addressing concerns, and I think the Chair's response was correct, that those particular concerns can be raised in a meeting. The Honourable Member is not here now. But I think we should consider very seriously issues that were raised, because from my side, if one looks at what we would consider were unfortunate decisions to, first of all, appeal the High Court decision and then the Constitutional Court, we need to take very seriously issues that Honourable Daniels has raised and not just dismiss it out of hand. We are bound by the Constitutional Court decision to ensure that this process proceeds, to acknowledge the rights of people. But let's not deny someone the right to raise legitimate issues, because I think all of us can learn from what many of us would argue were irrational. Chair, you yourself cited court cases around the Judicial Services Commission, Parliament's decision to nominate Honourable Hlophe. The court is asking, be rational, and so on, and overturn Parliament's decision, just like with the vote in regard to the independent panel. So let's consider those issues. Let's be rational and let's conduct ourselves in a way which safeguards the mandate that we have. Thank you, but I support your proposal.
Thank you very much, Honorable Dagmo, and thanks, Honorable Litpil Chavalala. So my take is that when there are issues, there's an item on the agenda that we are deliberating on. Let's deliberate on the matter in the meeting. And if we have taken a decision in the meeting and you want to raise the issues, when we consider the minutes, let's raise the matters there. That's what I would like things to work. That's why I responded in the way that I have, because I don't want to then go and respond whilst I take the whatever the feeling is and so forth. But we are in a meeting for a reason. Matters are deliberated here, and decisions are taken here. The decisions are minuted. The minutes of the meeting are given in the meeting, so that if there are errors in terms of how the minutes are captured, then they can be corrected. So let's do everything in the meeting. And if there are any correspondence that needs to be shared with members, let it be shared with members prior to the meeting, but let it not be after decisions have been taken. Thanks very much, and thanks for noting the responses, the correspondence, and the responses thereof. Can we then move to the second main item of the day, which is the terms of reference? So just as a way of opening, I know Michael Prince will come and present. So in the last meeting, we had gone through the terms of reference, and we asked legal to standardize, use the same language, ensure that all the views are consolidated. So the legal services will then now take us through the work that they have done, and then we will then ask questions and so forth. And given that the terms of reference were shared yesterday, and the revised version was shared late in the afternoon. So we'll ask questions, but then we'll give the political parties space to fully consider the terms of reference. But for me, the terms of reference are now at what I would call the semi-final stage. We are moving closer to finalizing the terms of reference, but I'll ask legal to take us through and indicate the thinking that went through the drafting, and why the choice of the drafting style was chosen, so that we are all on board in terms of how they've drafted the terms of reference for us. And the final thing that I want to say is that, like I indicated in the previous meetings, that the intent with the terms of reference is that they will then be made the order of the National Assembly, so that the future impeachment committees will not have to start from scratch. At least they've got a base to work from. So the drafting needs to be general rather than too specific, but allow for this particular impeachment committee to do all the work that it needs to do without having to recreate the rules. Thanks. Michael, you ready with your presentation?
Yes, good morning, Chair. Good morning, members. Good morning, guests. Chair, with your permission, I'd like to share my screen.
Permission granted.
By way of introduction, our office sought to align the committee's terms of reference with those of the previous two inquiries, namely the Section 194 inquiry and the ad hoc committees dealing with allegations made by Lieutenant General Mkhwanazi. In doing so, we also utilized generally accepted legislative drafting techniques in drafting the terms of reference. We attempted to make it as general as possible, considering your proposal that the terms of reference might be adopted as order of the House for future committees. We've also incorporated the applicable legislation and NA rules by way of reference, rather than repeating it in the text itself, as members will see as I move through the document. Turning to the document itself, it consists of a table of contents, which spans 2 pages. I'm not going to go through that, Chair. Just to say that we've noted that the general rules applicable to the Section 89 inquiry, as well as the Powers and Privileges Act, will be amended to the terms of reference, will be annexed to the terms of reference. The first section deals with background. Very briefly, it sets out the...
Sorry, Michael, can you just make the screen a little bit bigger? Just zoom the screen a bit.
Just 1 second, Jude. Is that okay?
It's perfect.
Thank you, Chair. Yeah, just by way of background, the background deals with the circumstances that occurred at President Ramaphosa's farm, where money was discovered. It then moves on to the motion that was submitted by Honorable Zungula. The motion being referred to the independent panel, the panel reporting on that motion, how the House dealt with the panel's report, voting it down and deciding not to refer the matter to impeachment committee, which led to the economic freedom fighters applying to the Constitutional Court for an order to set aside the decision of the National Assembly. Then goes on to that decision, the order being granted on the 8th of May 2026 by the Constitutional Court. Amongst other things, declaring certain rules of the National Assembly inconsistent with the Constitution and reading into those rules, and also referring the independent panel report to the impeachment committee, where it is now. And lastly, it deals with the composition and the appointment of the impeachment committee and its members, as well as the appointment of the chairperson. The second section deals with the definitions. This is where we've implemented legislative drafting techniques to streamline the definitions. There are no new definitions. We have removed certain definitions that were generally accepted definitions that are defined in terms of its ordinary meaning. These are not meant to be included in the definition sections. Definition sections are there to define specific terms with relevance to the document. So the definitions that's contained there are definitions that were in the previous document as well. Moving on to the legal framework, we set out that the legal framework that is applicable to this committee is the Constitution and the applicable sections of the Powers and Privileges Act, as well as the NA rules, in particular the rules, the general rules, Section 89 rules. We then state the various provisions of the Constitution that's applicable, Section 57, that deals with the NA's power to control its internal arrangements and proceedings, Section 59, which deals with public access to and involvement in the National Assembly, and of course Section 89, which deals with the removal of the President. The fourth section deals with the guiding principles. This is how the impeachment committee will conduct its work. I'm not going to read all of those principles. A few of them are respect for and adherence to the Constitution, accountability, openness and transparency, and to conduct inquiry within a reasonable time frame. To name just a few of those principles. A new section that we introduced was the scope of the Section 89 impeachment inquiry. I will proceed to read this entire section as it is new. The Section 89 impeachment inquiry is a constitutional process to establish, on the basis of evidence presented, whether the president committed one of the grounds listed in Section 89 of the Constitution. It is an inquisitorial process informed by Parliament's constitutional oversight mandate and the principle of fairness. The Section 89 impeachment inquiry requires the adjudication of the facts and applicable law. The primary purpose is to determine whether a ground listed in Section 89(1) exists, thereby giving effect to the requirements of accountability and transparency under Section 57(1)(b) of the Constitution. Determining whether any of the Section 89(1) grounds exist is not an inherently and exclusively democratic exercise, but predominantly an inquisitorial, factual, and legal exercise. This would involve gathering evidence, examining and testing evidence, distilling and ascertaining the facts from the evidence, and applying the law on a preliminary basis. The impeachment committee must proceed to establish the veracity and, where required, seriousness of the charges and report to the Assembly thereon. The next section deals with the impeachment committee, setting out the it deals with the impeachment committee. It says that the committee is established in terms of NA Rule 129J. It further says that the composition of the committee, the appointment of its members, including the alternates, are regulated by NA Rules 129K, 154, 155, 56, and 163. It then goes on to say the calling of meetings as well as the quorum of those meetings are regulated by Rule 161 and 162 respectively. The next section deals with the manner in which decisions are taken by the committee. It says that those decisions will be regulated by NA Rule 129N, read with Rule 158(2)D, all of which is subject to paragraph 11.10. That paragraph deals with committee deliberations and decision making. The terms of reference then outlines the role of the chairperson of the impeachment committee. It says that the chairperson's powers is regulated by NA Rule 158. The chairperson may, on resolution of the committee, issue directions from time to time. If the chairperson is absent, Rule 158, 159 apply to elect an acting chairperson from one of its members. Section 8 deals with committee secretary and support staff. Says that the secretary to Parliament must designate a member of staff as a committee secretary. The next subsection deals with the responsibilities of the committee secretary as per the job description. And the last section is resource allocation, which says that Parliament must provide the impeachment committee with adequate legal, research, administrative, and other resources in order to allow it to perform its functions. Section 9 is the evidence leader. There are various subcategories under this section. The one is the appointment of evidence leaders. The impeachment committee may request the secretary to facilitate the appointment of the evidence leaders. One, being the chief evidence leader, and secondly, being assistant evidence leaders who may be identified by the chief evidence leader. 9.1.2 is a reference to the directives that the impeachment committee has already issued, which is to determine the appropriate eligibility criteria for the appointment of the evidence leaders. 9.1.3 deals with the terms and conditions of the appointment of the evidence leaders, which must be agreed to in writing with the Secretary to Parliament and approved by the Solicitor General. Once appointed, the evidence leaders must perform their functions envisaged by these terms of reference and any other functions that the committee may assign to them. The committee may request the Secretary to Parliament to instruct the Solicitor General to debrief any evidence leader on good cause shown, whereupon the appointment process in 9.1.1 will start again. The role of the evidence leaders. Up front, we say that they owe their primary duty to the Constitution and to the impeachment committee, and they must carry out their role independently, fairly, and objectively. The chief evidence leader is accountable to the committee for the proper discharge of the functions of all the evidence leaders. And in addition, the assistant evidence leaders individually are also so accountable to the committee. The Section 89 inquiry is an inquisitorial inquiry. Therefore, the evidence leaders must present all material evidence relevant to the charges in the motion. It's important to note that the evidence leaders do not act as prosecutors. They must ask questions to the President and all other witnesses with the aim of empowering this committee to assess the veracity of the evidence in line with its mandate. What will be the format of questions and whether those are oral or by way of statements, that must be determined by the evidence leader in consultation with this committee. We then state that the use of the evidence leader will in no way limit or impede the right of members of this committee to put questions of substance or clarity to any witness in line with the committee's mandate, specifically reflected in Section 89 of the Constitution and the NA rules. What are the functions of the evidence leaders? The chief evidence leader must plan, coordinate, and oversee the work of the evidence leaders. Upon their appointment, the evidence leaders must diligently and without delay consider the motion and the evidence attached to the motion and the panel report and its annexes. Once they've done that, they must identify persons who and any bodies, or institutions which may have knowledge of the matter, relevant to the matter, may have in their possession information, documents, or real evidence relevant to the matter, who have expertise that will assist the committee in making its finding. Through the impeachment committee, they must request such people or the relevant persons to provide that information or to be interviewed. And they must conduct such interviews and consider all such information, documents, or real evidence provided to them. The evidence leaders must thereafter recommend a list of witnesses that may be called to present evidence and documents or real evidence that may be presented to the impeachment committee. The next section deals with the President as a role player within the impeachment process. In terms of Rule 129M3, the impeachment committee must afford the President the right to be heard in his own defense and to be assisted by a legal practitioner or other expert of his choice. The President or the legal practitioner, in his capacity as a representative of the President, may make opening and closing statements, cross-examine witnesses, make such applications to this committee as referred to in the paragraph below, and raise any matter related to the process subject to any reasonable time restrictions that this committee may impose. After receiving a notice referred to in a paragraph below, the President must provide the impeachment committee with a physical, postal, or email address for service of any documents and correspondence. The Section 89 impeachment inquiry and what it entails. We start with the objects of such an inquiry. The objects of this inquiry is for the impeachment committee to assess the charges contained in the motion and to establish the veracity and, where required, seriousness of the charges, and thereafter to report to the Assembly thereon, as per NA Rule 129M1. The impeachment committee must, as soon as reasonably possible, notify the President of the commencement of the inquiry, and together with that notice must provide the President with copies of the rules and these terms of reference. They must also publish on Parliament's website or by any means of such other media a notice containing the addresses to which persons may send correspondence to the impeachment committee and make applications to the committee in accordance with these terms of reference. Regarding opening remarks, at the first meeting where the evidence of the first witness will be presented, the chairperson may make opening remarks and the evidence leaders may make an opening statement, such statement being limited to a period of 1 hour unless the chairperson determines otherwise. After the conclusion of the questioning of the last witnesses presented by the evidence leaders, the President or his representative may make an opening statement, such statement being limited to a period of 1 hour unless the chairperson determines otherwise. How will we deal with witnesses? Firstly, in general, the committee may invite the persons identified by it or on the advice of the evidence leaders as witnesses to submit a sworn written statement and to thereafter appear before it, if determined necessary, to answer oral questions relating to the subject matter of the inquiry. The applicable sections of PIPLA apply to any person who has agreed to appear before the impeachment committee to give evidence or to produce documents relevant to the inquiry. All witnesses will be requested to submit their signed, sworn, written statements, including any supporting evidentiary documents, at least 7 working days, excluding weekends and public holidays, prior to the commencement of their testimony, provided that the statement and any evidence is limited to the information contained in the scope of the inquiry. A witness may be assisted by the evidence leaders to prepare a statement or a statement for submission to the committee. The committee will furnish the President with copies of all statements as received and a list of all witnesses it intends calling. The first of the specific witnesses, the expert witnesses. The impeachment committee may, of its own accord, or on the advice of the evidence leaders, request the Secretary to Parliament to appoint an expert witness to assist it in making its findings. And these expert witnesses may include data analysts, forensic investigators, foreign currency experts, or exchange control specialists. Witnesses called by the evidence leader. The evidence leader will present the evidence of witnesses referred to in paragraph 4.1.a of the impeachment committee. Every witness presented by the evidence leaders may, after the evidence leaders have finished presenting the evidence and putting any questions to them, be questioned by either the President or his representative, such questioning and answers being limited to a period of 1 hour. Next, such witnesses may be questioned by any member of the impeachment committee who wishes to do so, each member's questioning being limited to a period of 30 minutes without considering the time used by the witness to answer such questions. And thereafter, they may be re-questioned by the evidence leaders to clarify any answers given to questions posed by either the President or the President's representative or members of the impeachment committee. Such further questioning and answers thereto being limited to a period of 30 minutes, all of which is underscored by the proviso that the chairperson may determine such other time periods. Moving on to the President's witnesses. Every witness presented by the President or the President's representative may, after the President or his representative has finished presenting the evidence and putting any questions to them, be questioned by the evidence leader, and for a period of 1 hour. Next, be questioned by any member of the impeachment committee who may wish to do so, and that is for 30 minutes without considering the time used by the witness to answer such questions. Thereafter, they may be re-examined by the President or the President's representative to clarify any answers given to questions posed by either the evidence leader or members of the committee, and that will be for a further 30 minutes, all of which, again, under the proviso the chairperson may determine such other time periods. The President or the President's representative may not present evidence of a witness whose evidence has already been presented by the evidence leaders. Now moving on to the President's testimony, the President appearing as a witness. After the evidence leaders concluded presenting the evidence, the impeachment committee must, in terms of Rule 129(m)(3), afford the President the right to be heard in his or her own defense and to be assisted by a legal practitioner or any other expert of his or her choice. The President may be assisted by a legal representative to present his evidence before the committee, but the President himself must give the evidence and answer any questions posed to him during their testimony. When the President testifies, the following order applies. The President may make a statement, or the President's representative may be, or the President's evidence may be led by the President's representative, bearing in mind the previous paragraph that said the President himself must answer questions. Such statement or leading of the President's evidence will be limited to a period of 2 hours. Next, the President may be questioned by the evidence leaders, such questioning and answers thereto being limited to a period of 6 hours. Thereafter, the President may be questioned by any member of the impeachment committee who may wish to do so, and that is for a period of 30 minutes without considering the time used by the witness to answer such questions. Whereafter the President may be redirected by his counsel to clarify any answers given to questions posed by either the evidence leaders or the committee, members of the committee, and that is for a further hour. All of which, again, is under the proviso that the chairperson may determine different time periods. The next category of witnesses are witnesses presented by members of the impeachment committee and evidence by members of the public. Any member of the impeachment committee may apply in writing for leave to present a witness or documentary and or real evidence on any matter relevant to the motion. They must succinctly set out the matters the witness intends to testify about and attach documents in question, or true copies thereof, or succinctly describe the real evidence in question. And in the case of an application for leave to present a witness, they must attach a sworn statement signed by the prospective witness confirming their willingness to testify before the committee. Any person may apply in writing to the impeachment committee for leave to present oral, documentary, or real evidence on any matter relevant to the motion. Again, they must succinctly set out the matters the person intends to testify about and attach the documents in question or true copies thereof, and succinctly describing the real evidence in question. Upon receiving an application referred to in either A or B above, the committee secretary must send or deliver copies to the evidence leaders. Once the evidence leaders receive those applications, they must determine the relevance of the evidence, and if they deem it necessary, contact and interview the applicant or the prospective witness. Thereafter, they must advise the impeachment committee whether or not to grant or refuse the application, setting out the written reasons for the advice. On receipt of the written advice, the impeachment committee must decide whether or not to grant the application and record reasons for its decision. If the committee grants the application, the evidence leaders must assist the witness to prepare a sworn written statement and comply with paragraph 11.4.9 below, if applicable, and thereafter present the witness's evidence to the committee. The next category of witnesses are witnesses summoned or brought from prison. If the committee, of its own accord, or at the written request of a member, the evidence leader or the president, if consider it necessary, that a person be summoned in terms of section 56A of the Constitution to appear before the committee to give evidence or to produce documents relevant to the inquiry, the process referred to in section 14 of the Powers and Privileges Act, read was Rule 167A of the NA Rules apply. Or if the role players above consider it necessary that a person who is being detained in any prison be brought before the impeachment committee to give evidence or to produce documents relevant to the inquiry, the process referred to in Rule 361 of the NA Rules apply. If the committee, whether acting of its own accord or pursuant to written requests, resolved to summons a person to appear before it to give evidence or to produce documents relevant to the inquiry, the chairperson, acting through the committee secretary, must seek the concurrence of the speaker. And if the speaker concurs, the summons must be issued by the secretary to Parliament in terms of and in compliance with section 14(2) and sub 2 and 3 of the Powers and Privileges Act, and served in accordance with section 14(4) of the Powers and Privileges Act, whereupon sections 14(5) and 6 and section 15, 16, and 17 of PUPLA applies. Claim of legal privilege or confidentiality in relation to witnesses. If a witness who intends to produce a document to the committee claims that the document is privileged or confidential in terms of law, the committee must consider that claim in terms of NA Rule 189. Witnesses who during testimony implicate others. On the advice of the evidence leaders, the impeachment committee must notify in writing within a reasonable period a person who is implicated in wrongdoing in a witness statement within a reasonable period before that witness testifies, or a person implicated in the wrongdoing when a witness testifies within a reasonable period after that witness has testified. Moving on to evidence. Evidence before the impeachment committee. The evidence of all witnesses must be presented orally unless otherwise directed. The only evidence that the evidence leaders and the president may present, the witness may give, and the impeachment committee may rely on, is evidence relevant to determining the veracity of a charge in the motion, and when necessary, the seriousness of such a charge. What are such evidence? Well, what may it include? Such evidence may include hearsay evidence as regulated by Section 3 of the Law of Evidence Act 1998, and objective expert opinion evidence on questions of fact that would be admissible if adduced in proceedings in a court of law. The authenticity of any document or real evidence presented to the impeachment committee must be proved by oral testimony of a witness testifying before the committee, or in such other manner as permitted in terms of African law of evidence. The impeachment committee may not base its decision on the veracity of a charge in the motion, and when necessary, the seriousness of such a charge on a document or real evidence which is not proved in accordance with the requirements I listed above, or which was obtained or disclosed illegally by a party presenting it or the witness concerned, unless the committee determines having regard to all the relevant facts and circumstances, reliance on that evidence is reasonable and justified in an open and democratic society. Recordings and transcriptions of meetings. The meetings of the committee must be recorded and transcribed within a reasonable time. The committee must ensure that a full record of its business is kept in accessible format, including correspondence, applications, documents, etc., received by the chairperson and the evidence leader and or presented to the committee. How will applications before the committee be handled? Any person who wishes to make an application in terms of the terms of reference must do so by means of a written signed document addressed to the committee secretary, at or by means of any of the addresses set out in the notice published in terms of the above paragraph, and that notice and that application must specify the paragraph of the terms of reference in terms of which the application is made or the subject matter of the application. And it must provide an address at which they may be contacted and receive correspondence from the committee. The applicant must cite in the application every other person whose rights may be affected by the order sought and deliver a copy to every such person and furnish this committee with written proof of delivery. Conduct during or in relation to proceedings. The members of the impeachment committee, the evidence leaders, the president or his representative, and any person appearing before the committee, any member of the public or the media attending proceedings of the committee must obey any directions and conform to any procedures determined by the chairperson aimed at ensuring the orderly and proper conduct of proceedings. They must treat all parties with respect, and they must conduct themselves in a manner befitting the dignity and decorum of a forum of the National Assembly. How will this committee deal with public participation? This will be done through a general call for witnesses, documents, and real evidence. Section 59 of the Constitution provides the Assembly must facilitate public involvement by affording the public a reasonable opportunity to participate in its committee processes. The committee must make a general call to the public for witnesses, documents, and real evidence relevant to the charges in the motion and publish it by means of such media as the chairperson may direct. Committee deliberations and decisions. If, after the evidence leaders have concluded presenting the evidence, the impeachment committee concludes that the available evidence is insufficient to support the charges or that the charges cannot reasonably be sustained, the committee may resolve that inquiry should not continue. The committee may resolve that the inquiry should not continue and submit a report setting out its findings and recommendations to the Assembly. If the impeachment committee resolves not to discontinue the matter in terms of the above paragraph, then, after the conclusion of all the evidence, the impeachment committee must meet to deliberate and decide the veracity and, where required, seriousness of the charges against the president contained in the impeachment motion. And if the committee decides that the charge or charges is or are established, whether to recommend to the Assembly that the president be removed from office and the reasons for that recommendation. In relation to a charge of a serious violation of the Constitution or the law, or of serious misconduct, this committee must decide whether the president has violated the Constitution or the law or misconducted himself as alleged, and if so, whether the violation or misconduct is serious. When deciding whether violation of the Constitution or the law or misconduct is serious, the impeachment committee must consider, in the case of a violation of the Constitution or the law, whether the behavior of the president amounted to an intentional or malicious violation of the Constitution or the law performed in bad faith, and B, in the case of misconduct, whether the behavior of the president was unlawful, dishonest, or improper and performed in bad faith. In relation to a charge that the president is unable to perform the functions of office, the impeachment committee must decide whether the president is suffering from a permanent or temporary physical or mental condition which renders him unable to perform the functions of office, and if the condition is temporary, the likely duration thereof. Closing remarks. The committee has concluded after the committee has concluded its hearing and received all evidence, the chairperson must afford the evidence leaders and the president an opportunity to make closing remarks, such statement being limited to a period of 1 hour, unless the chairperson determines otherwise. Committee report. In terms of NA Rule 129.01, once the committee has concluded the inquiry, it must report to the Assembly forthwith. In terms of 129.02 of the NA Rules, the report of the committee must contain findings regarding the charge or charges in the motion, calling for the removal of the President from office in terms of Section 89(1) of the Constitution, and a recommendation as to whether or not the President should be removed from office, including the reasons for such. Dealing with the venue, the committee meetings will be held in person within the parliamentary precinct or any other suitable venue to be determined by the committee. Where necessary and for purposes of accommodating persons who are witnesses and who are unable to physically attend meetings due to exceptional circumstances, on a written application to the chairperson and upon approval by this committee, those witnesses may be accommodated by attending the meeting virtually. Just to note that this was a section that was taken from both of the previous inquiries conducted in Parliament. And in general, these terms of reference are adopted to ensure the efficient functioning of the Impeachment Committee and are not intended to be exhaustive. Any procedural matter arising during the proceedings of the Impeachment Committee that is not explicitly addressed must be resolved by direction of the chairperson. Before giving any direction, the chairperson must give due consideration to the rights of all parties to be directly affected by the proposed direction and consult with the Impeachment Committee. Chair, thank you. We present the draft terms of reference. Thank you.
Thank you very much, Michael. Honorable members, here's the cleaned up version aligned in terms of the language for your initial take, but as indicated, we would like to then also give you enough time to consider this, what I will call the semi-final version of the terms of reference. Honorable Sat.
Thank you, Chair. Firstly, I'd like to thank the presenter for the work that has gone into this document. And I appreciate your comment that we do need time to go through it, given the fact that it seems to be vastly different from the terms of reference that we were considering and the party inputs that were made. And I do recall that I suggested we give a large degree of discretion, which seems to have been adopted. And I do want to have the opportunity to go through this in more detail and come back with further suggestions. One of the issues that does not seem to have been covered is the issue of the proof, the balance of what is required. And we've had that debate. What do we need to prove? Is it, and what is the standard of evidence required to satisfy the crime? And I'm interested, I might have missed it, but we had lengthy discussions on that, considering that this is a unique process. It's not a criminal process beyond reasonable doubt. It's not a civil process on a balance of probabilities. It's a unique process in between. And the last suggestions related to that, the proposal that of an inquisitorial model, which the findings would require and satisfy the constitutional requirement of legality, rationality, and procedural fairness through reliable evidence. And that was set out in the legal opinion at paragraph 26. I'm not sure if I missed it, but should there not be a more specific guidance in the terms of reference as to how the members of the committee reach their conclusion and what standard of proof is required? I do think that that will be helpful, but I'd like comments in that regard. And then we'll come back with further comments in due course once we've gone through the documents. But this is just my initial comments on the document. Thank you, Chairperson.
Thank you very much, Honorable Swart. Honorable Dagmo.
Thank you very much, Chair. Also want to echo the sentiments thanking our parliamentary legal services for all the work done and the presentation. I think the document is beginning to shape up, but we also believe that there should be an opportunity for parties to do a final consultation and check. I just wanted to ask whether we could just look at one or two issues. If we could go to 11.4.2, there is that provision around the time allocated, 11.4.2, the time allocated to the president. No, sorry, that was expert witnesses. I think, sorry, no, that distinction, I think, has now been dealt with. The issue of, expert witnesses, and what has been raised by members previously about the need for the impeachment committee itself to have, various investigators. So I think that issue now, as far as I can see, draws a distinction between expert witnesses and then what I'm basically trying to say on this point, if I can just clarify, and then maybe it can be a quick response. The issue is that we have had a discussion around the to appoint expert witnesses. But there is also, in calling, is every other witness who is not a sort of so-called expert witness just a witness. In other words, you might call someone to give evidence from the Reserve Bank who might not be what is referred to in regard to Parliament appointing an expert witness. So in other words, just a terminology there, I think it would be useful to, just draw that distinction between expert witnesses appointed by the committee, and then others who are witnesses but might be regarded as experts. It's maybe a technical point, but I just wanted to raise that point. And then 11.4.5, I think it goes to the issue of, if I've got this right, the time allocated. I know there's always the qualification at the end where the chair, where the chair is able to, make a ruling. But in regard to this issue of the president's testimony, there is that reference to time. I think being limited to, I think it's initially, there we are, may make a statement, or the president's evidence may be led by the rep. Such statement or leading will be limited to a period of 2 hours. Now, given that that's the kind of initial reaction in terms of the president's evidence, I wanted to ask whether there should not be a consideration that in terms of that we refer to a reasonable period. Obviously, you do have the provision for the chair to then rule, but it would seem that the initial evidence from the president, it should be a reasonable period, not necessarily restricted. So I just wanted to I know we have that qualification where the chair comes in, but I thought given that this provision is actually talking to the president's initial statement, I want to request consideration, not now, but when we finalize, of a reasonable period as opposed to limiting that to 2 hours. And then we have had a discussion as the committee, on what some of us have referred to as, the staging of this process. And there has been an argument around the issue of, calling a number of witnesses, and then when that particular process of gathering that evidence is then put to the president. So it's not necessarily a two-phase, but it's more the order of proceedings. And I know that initially the legal advice, was to say that, this is a full-blown inquiry. I think no one disputes that it's a full-blown inquiry, But in terms of an approach, in other words, hearing particular witnesses, gathering all of that witnesses, and then, calling the president, it's, to me, I think it will just assist the work of the commission. And I just wanted to ask whether the legal advisors believe that such a structure of the proceedings would in any way undermine what is a full-blown inquiry. I think we need to consider that matter. But thank you very much, Chair, once again, for all the work done, and we support the proposal of time being given for parties to have a final look at everything. Thanks.
Chairperson, my hand up as well. Thank you.
Thank you very much. Honorable Mutam.
Thank you, Chair. Two quick points. And I appreciate that we will have another bite on these terms of reference after carefully considering them. But I just want a little bit of clarity on the provision for witnesses appearing virtual. If I heard correctly, there is that provision, Chair. If it is true that the witnesses might appear virtually, would need a good reasoning for that. Because, Chair, I was going to suggest that we get rid of that provision, that all witnesses must appear in person before the committee, so that we're able to have meaningful interactions, which would take care of all the possibilities of a witness answering questions. That's just one thing. The other, Chair, is a matter that you seem to resist. And I think this is the third time I'm raising it. If it doesn't belong to the terms of reference, let's find a place for it. And this is the suggestion that we must have a inspection in loco in Palapala itself, the site of the alleged wrongdoings. As a committee, we can't be operating in the dark. We need to get a good sense of the coordinates, the physical space which we are discussing in this committee. So I don't know if it belongs to the terms of reference or it belongs elsewhere. If that is true, then we must reflect it so that we come back to it. Added to that, I want to suggest that the legal team already worked on the necessary processes that will guide such a visit, which will not compromise evidence or undermine the process itself, this process we are undertaking. So I'm not suggesting a gang-ho, skid donor process. I'm asking for a well-considered, legally permissible visit to the site of the alleged wrongdoing we are dealing with in this committee. Otherwise, Chair, we'll be operating in the dark. Thank you.
Thank you very much, Honorable Advocate Breitenbach.
Thank you, Chairperson. Yes, I agree with the Honourable Lichfield Chabalala that we would, in all probability, require a inspection in loco, and how we deal with it. Perhaps we can get some advice on the next time. We'll also consider these terms of reference carefully and make submissions. But in the interim, Chair, I would like the legal advisors to give some thought to the implications of calling expert witnesses. There are certain criteria that need to be met in order to qualify as an expert witness, and they should, and we'll deal with this at the next opportunity. But just in the interim, let them apply their minds to what those requirements are and how we will propose to deal with expert witnesses, and how we will go about proving the veracity of their expertise. Thank you, Chair.
Thank you very much, Honorable Mutambi.
Thank you, Chair. While one is aligned with the earlier proposals, I think there are issues as and when we'll be commenting on the final terms of reference. One would like to get clarity on, so that as and when we comment, then we'll have heard this, what is the intention of these other clocks. Let's look at 11.44B. (11.44B). It reads, the president or president representative may not present the evidence of a witness whose evidence has already been presented by the evidence leaders. Chair, if you interrogate this provision, it is unclear and raises a number of interpretive difficulties, which is of principal concern for us is whether this provision precludes the president from calling in his defense a witness who has previously testified for the evidence leaders. Or alternatively, it may mean that such a witness may be recalled, provided that the evidence elicited relates to a matter not previously canvassed during the evidence leaders' examination. So I'm trying to look at this wording. To me, it's difficult to interpret in that it's not clear whether the reference to a witness evidence is intended to mean the witness testimony, or whether it encompasses the broader evidentiary value of the witness contribution. So I should think as to the drafter of this must then provide some greater clarity on the intended scope and the effect of this provision. That will, I think it will assist us a great deal. Also, when you look on clause 11.3, Chair, you look in with regard to the opening remarks. When you look at this clause, Chair, you will see that the chairperson and the evidence leaders are permitted to make opening statement at the commencement of the proceeding. However, when you go down further, it means that the president may only make an opening statement after the evidence leader's final witness has testified. And then with this arrangement on paragraph 11.3, it therefore permits the evidence leaders to frame the issues and establish the narrative from the outset of the proceeding. Then if you are to look at a practical matter, you know that the first impression often shape the audience perception of the evidence that follows. What I'm trying to say, Chair, is that the opportunity to make an opening statement free from immediate interrogation provides an important mechanism through which a party may contextualize its case and direct attention to its principal themes. And then if we're striking the balance in all fairness under the circumstances, I should think also the president is deprived that opportunity at the outset of this proceedings. So it will be important that maybe also with regard to there's a crafting that deals also with the president's opening remarks, unlike after all the evidence leaders' final witnesses has testified. So these are some of the issues that we need to look at that. With regard to 11.4.3b2, you at least Honorable Darkmore has also raised this, but I should think if you look 11.4.3b2, it permits each member of the committee to question witnesses with a limitation of 30 minutes applying only to the committee members questioning and expressly excluding the witness answers. And then if you are to look at the practicality part of it, it creates the possibility that the examination of a witness by a committee member could far exceed the time afforded to the president as well, given that the questions are typically far shorter than answers that they elicit. A committee member could, within a 30-minute questioning period, ask a substantial number of questions and then thereby engage a witness for a significantly longer period. So I think the lawyers will talk to you about the procedural fairness concern on this, because if this doesn't get addressed, there's a limitation on the president's ability to cross-examine witness it himself. And then also this provision, then it gives the committee members a more greater effective access to the witness than the president himself. And the president is the person whose conduct is under scrutiny. So then it means then the president also at the same breath must be given adequate time to test the evidence adduced against him. But these are the matters that we'll have to, that's why I'm putting it so that the drafters of this document also can also tell us whether this can also not be expanded to him, because what the basic principle is here, it's when you are dealing with the fairness part of the matters, then for the procedure to be fair. So in any other thing that happens, because there's also like an issue that is raised where the committee makes decision on processes like hearing a person on camera or not, under the circumstances. What also this person under scrutiny, he must also have the right to object, because if he doesn't have that, then it limits his rights for a full process. So that the issue wherein maybe as we continue for the drafters, maybe they must also insert a provision that the president also be given an opportunity to raise objection of processes and have an opportunity before the decisions are taken by the committee. These are some of the things that as one was reading this. So some loopholes, but I think the drafters will be able to comment on that, because these are also the issues that we raised last time in our meeting. And the other issue that Honorable Swart raised is on the test. The test that on the test, I don't have to repeat myself because this seemed not to have omitted it on the legal test on proving the case. Thank you, Chair.
Thank you very much, Honorable Mutambi. Honorable Hlope.
Thank you, Chairperson. First of all, I would like to join the previous speakers to thank the legal team for such a presentation. Clearly, a lot of work has gone into, but as political parties, we must be given time, a reasonable time, within which to go through this and make an input. I would suggest a week or so, because the matter has been going on for a very, very long time. Certainly, we cannot be seen to be wanting to delay it any further. Secondly, the suggestion that was made by Honorable Dagmore that the president must be given reasonable time, which is not defined, which will be controlled by the chairperson. I do not agree with that suggestion. We need to specify time. For purposes of this inquiry, we must remember, and this is important for South Africans to remember, the president is an ordinary party. He is the one who must be accountable. He's entitled, yes, to be treated with dignity, but he's no special person at all. We respect him as the head of state. But the issue is that for purposes of this impeachment inquiry, he is an ordinary party. He can't just have the latitude of appearing for as long as he likes. So I do not agree with the suggestion that he must be given a reasonable time. Clearly, as Honorable Swart highlighted, there are quite a number of other provisions that are matter of concern where we need to find each other, consult widely as political parties and as political formations, and come back. So the idea of being given some time is a sensible suggestion. On behalf of MK Party, I would say we support that. Finally, whilst I'm on air, Comrade Mqwetama has raised this for the third time, the need for us to have an inspection in loco. An inspection in loco is a preliminary, it's part of what we call a preliminary investigation. There is no doubt that there will be a need to visit Palapala, and it should be done before the actual evidence is laid in the proceedings, so that we go there with an open mind. We have an idea of where this money that was stashed under the sofas, where was the sofa located in relation to the rest of the house. That's something that cannot be swept under the carpet. And I fully support Comrade Mlitam. He has raised it, and this is the third time today. At some point, we would like this to be dealt with or taken seriously because it's a sensible suggestion. And as MK Party, we insist that it must be taken seriously and be addressed before the public hearing takes place. It's time to deal with it, and it must be provided for in the terms of reference. Thank you, Chairperson and honorable members. I submit.
Thank you very much, Honorable Mauta.
Thank you, Chair. Chair, we appreciate that. Obviously, we'll have time to go through these terms of reference before we can consider and adopt them. But Chair, it can't be correct that the parliamentary staff, they now behave like politicians. We've been seized with this document for a very long time. We've had this presentation 3 or 4 times already. We submitted our inputs, and we explained why we submitted our inputs. In the last meeting, Chair, we went at length, clause by clause, explaining ourselves once and again about these clauses. Now, for the parliamentary staff to just come and say, this is in line with history, or it's in alignment with history, that's wrong. We reject that. I mean, one of the things that we advocated for as the EFF was to say, the issue of the venue. We need to have a clear, secured venue where evidence will be heard. And now we're told that this has changed because it's in alignment with history. That's wrong. We reject that. There's substantive issues that have changed from where we were up to now. I hear even colleagues saying the issue of Honorable Darkmo was saying the two-step process that was defeated, and we're not going to reopen it. We're not going to be going in circles all the time. We have to reach a point where we conclude on this issue, but we will not for as long as the drafters, staff members, go and change the decisions that are made by politicians. We need our document that we worked on the last time, because this one, there's substantive issues that have moved away from what we were talking about. And we want to caution the staff, because we're not disabled to draft our own document. We are professionals, we can do it. But we're saying we've got other obligations and other responsibilities, and therefore they should do it on our behalf. We're paying them to do what we're asking them to do, not for them to come and now make input as if they are members of this impeachment committee. They are not. They are a support staff that is supporting this committee, and it must remain like that. So we're going to have to go back to these terms of reference, and we're going to have to close them with the inputs that we made, not the inputs that are made in a boardroom sitting somewhere where we don't even know where you're getting instructions from. There's no instruction that says align with history. No, we reject that notion, Chair. It must be very clear. So let's get these terms of reference. And as political parties, we're going to sit and go through them once again. And if they don't satisfy what we had already submitted, we're going to have to reopen this. We're not going to be forced to adopt something that doesn't speak to what we agreed on as political parties, because we lobbied each other before we came to our last meeting. And now to take us back the way these terms of reference have taken us back, it's as if we have not done anything. We went clause by clause, individual as political parties. Then we consulted each other. Where we couldn't find each other, we said, okay, we'll look into it. And now that has all been taken away, and we're seeing a new document here that is not what is talking to the issues that we have raised. So we need this document, and we will consult with each other and bring it back to where it was supposed to be in the first place, because no one is going to want to go against us or behind our backs to change what we have discussed and agreed on. Thank you, Chair.
Thanks, Honorable Maud. So just to indicate, honorable members, that one of the things that we did agree, and we must not, attack the support staff. So what we agreed was that there needs to take the comments that were made in the last meeting, ensure that there's consistency of language, clean up the document, and present the document. So the support staff have presented the document. At the end of the day, it is ourselves as members who are going to accept the document. If there are aspects of the document that needs further refining, it's for us to refine those documents, the terms and the clauses. But I feel that the support staff, the legal team has done well in terms of putting all the varying aspects, and if they've been captured fully, that which we had indicated, or that which you had indicated last time, there needs to be at that point. And that's why I'm giving each one a time to look at this. But we need to appreciate the work that the support staff is doing on this particular this document, and they are developing it and assisting us at all times. So let's also appreciate the work that they've done and they continue to do in guiding us. If there are aspects that we don't agree, let's indicate the aspects that we don't agree. And that's why we are giving it an extra time, so that we can finally find each other and we can have the terms of reference that guides us. Because at the end of the day, it is the terms of reference of the committee, and this is the work of the committee. Honorable Ngobe.
Thank you, Chair. Mine is just a short one, just to say that, our sense is that these terms of reference really need to be strengthened. I think the spirit of the terms of reference for us is what needs to be captured. Our concern is that, these TORs need not, favor the president, nor the accusers of the president. These terms of reference must really just favor the truth, right? So we have been constituted as this committee as a result of the Constitutional Court, that required us as Parliament to perform our duty that was not previously discharged properly according to the judgment. And so we should be extremely careful not to build procedural escapes through this inquiry. I say this because there are certain clauses that can lend themselves to such an escape. We will need the evidence leader in this regard to assist us, but the evidence leader cannot replace us. I was listening very carefully to Honorable Mutambi in her submission, and we agree that the president must enjoy procedural fairness fully as an individual in this country with full rights. But that fairness cannot mean immunity from questioning. And there should be no majority that should be able to terminate our search for the truth before material evidence has been properly tested. I think our posture here, Chair, and I'm imploring all of us as this committee to not be anti-Ramaphosa, but to be relentless in our search for accountability, and we must be procedurally on point, such that it will be difficult for our decisions here to be challenged. I think that was a spirit with which we commenced this meeting. And so we will absolutely relook at these terms of reference. There are about a couple of clauses that really prompted me to make the remarks that I'm making without going clause for clause, because I don't think, in the interest of time, that will be helpful. But our view is that because we are setting a precedent for a committee that has never really taken place in South Africa before, these terms of reference really need to be tightened and not allow for any kind of wiggle room and a sense of ambiguity. We will submit to that effect. I just wanted to make those remarks so that I think the spirit of the terms of reference is what is really concerning us from the last meeting that we had discussing this particular item. Thank you, Chair.
Thanks very much, Honorable Litchfield Chavala.
Thank you, Chair. And I know you have answered it on behalf of the staff members, but so that we don't keep adding these unnecessary stop and go, Chair. Yes, we had agreed that they need to clean it up, put it in a language that, is legal. But that should not change, man. That's editing. Don't alter certain things, because it then becomes very disingenuous when you look at it from a party like us that is in opposition. And I'm sure that's how other progressive parties here feel, the progressive opposition. Don't alter, because it just feels like you are now forcing us to go and read, amend again, and then you put it in a language that was not the spirit in which it was said. Then we shall amend again. It's honestly, it's like one step forward, two steps backward. So I appeal, use your chairpersonship. Editing, if I write a book and I give it to publishers and they edit, they cannot change the spirit within which it was written, then it means they are writing their own book. They are not editing my book. So I am appealing, Chair, because these things just becomes another way of stalling the process. Thank you.
Thanks very much. And I'll ask legal to come in and respond. Just a couple of points that Honorable Mutama did raise in terms of the inspection in loco. So in the last meeting that I had said was that once we have the evidence leader, it's always important that when you do this, even if you are going to do an inspection, the evidence leader is appointed, and they've gone through the document, and they've indicated that this particular course of action is going to aid the committee in terms of verifying the charges that are contained in the motion. So I did not dismiss the matter, Honorable Mutama. I said once the evidence leader is appointed, then this will be part of the processes that will be taken on board. The other aspect, and legal will come and respond as it relates to the clauses that require clarity, just so as to, and this is how we must receive the clarity that is going to be given by the legal advice. It's just to help us as we go and consider the terms of reference, in terms of the thinking that has gone in, the considerations that have gone in, and if we want to have a different configuration, we need to do that. I think one of the things that we have to be also, and I mentioned this, that we don't need to be too specific in certain matters. So it might very well be, and I say this in terms of the venue, it might very well be that certain witnesses, we might need to go to a specific venue outside of Parliament to go and interact with them, in the same way that the ad hoc committee into the allegations made by General Mkhwanazi had to go to Kgosi Mampuru Correctional Facility to conduct its business. So we need not constrain ourselves that there's just one venue that we will do our business. And so if, say, for instance, in the same way that the inspection in loco, it's proposed that on that particular day, that inspection, that place might very well be designated as a venue for the meeting. So we need to also be general or try to think much more broadly than how things are currently are. And the other aspect that we need to consider, it's what is built in terms of the general provision. There are things that at the moment we do not know, and we need to make a general provision that as things develop, as we do our work, we can be able to develop our own procedures and how things are done. So not everything will be as we know now. Things will develop as we peel through and trying to get to verify the charges and get into the evidence and so forth. So we need to build in the things that we currently do not know, and we must not work as if everything will stay as it is. And it might very well be that, say, for instance, when the construction of Parliament is concluded, or there's a venue that now becomes available that's even more attractive than the Good Hope Center, we might have to use that. But I'll allow legal just to give responses in terms of the points raised by Honorable Swart on the inquisitorial, the balance of proof or standard of proof, the questions in terms of opening statements, and the points raised by on the virtual witnesses, and also the clauses 11.4, 11.3, and 11.4.3 raised by Honorable Mthandi and the other members, just to help the members as they consider these draft terms. I got muted. If you could just respond to that. But one last thing that it is for ourselves to seriously consider, and I raised it in the first meeting, the time allocation. I know that it's built in there, the 30 minutes excluding the responses. We need to consider that we are a big committee with 30 members, and if each member question and answer, let's say it's 1-to-1, so a minute to minute from the question to responses, that it takes 1 hour for a member to interact, for one member to interact with a witness. It will mean that the total time for one witness will be as much as 30 hours, which is almost 3 days. So it's something that I raised in the first meeting, but please do consider the time allocations, because we are a committee of 30 members, and if each member is going to have 30 minutes to ask questions, let's say there's 30 minutes to respond to the questions, it will mean that one witness as a committee will have to interact with that witness for 30 hours. So let's just consider these practical implications, especially on the time. Michael or Suen, can you just come respond to some of those questions that have been raised, and just empower the members as they consider fully the document? What are the aspects that they do need to, as they consider the document, to look at, and also take them through your thinking in terms of the how you consolidated and synthesize the views that were expressed in the previous meeting. Thanks very much. Michael or Suen?
Thank you, Chair. I'll take a few questions, then my colleagues and Isaac will take the rest. Chair, just to say that we welcome the proposal that members will have an opportunity to seriously consider the document and then provide written inputs to us to consider. This is a document for the members. We, as support staff, have just tried to accommodate their request as far as possible, and this was our attempt to do so, Chair. Chair, just to go to specific questions that were asked, the one on standard of proof. As previously stated, at the last meeting, this is a unique process. And the difficulty that we have is that we're sitting with two standards of proof, each one being, in our view, slightly inappropriate to apply in these circumstances. We then referred the members as to the Constitutional Court judgment and the guidance that the Chief Justice has given in how members should deal with the law and the facts. And that we tried to capture in 5.1 of the document. If I could just share my document again. In 5.1 of the document that deals with scope, we tried to cover the wording of the Chief Justice there, where she said how the grounds must be determined, involving the evidence examination, the testing of the evidence, how it must be distilled. Chair, but members are welcome to come with proposals of how that might be tightened up to provide a more clear standard. That was our attempt to guide the members in that regard. We note the issue about the expert witnesses, Chair, and it may be something that we might want to consider if we receive something in writing from the members for our next presentation. Again, the issue about the president only being afforded 2 hours, and that should be changed to a reasonable period. Again, this is maybe something that the committee must consider and advise us what is a suitable period to include there. On that issue, members will note that we received various proposals on those issues, and the proposals were, in the majority, were to reduce those time periods as far as the president is concerned, and we've accommodated that. There's now another proposal that should be made a reasonable period. Again, this is something that the committee needs to consider and advise us to say this is the committee decision, and then we will incorporate that in the next draft. Again, the same with the structure of proceedings and whether it undermines a full-blown inquiry. The structure of proceedings is as we've captured it there, with the evidence leader leading his or her evidence first and thereafter the president. Again, if I don't know if I can take that point further, but and I don't want to venture into a full-blown trial argument. For us, the issue that we discussed was that the evidence leader will present, a proposal again was made, and this was a proposal that we've accommodated and that the committee must decide on, that stems from a statement that the Chief Justice made, that if at a point where the evidence leader, and this follows the structure, evidence leader first, presenting evidence, and if at a point where the evidence leader has closed his or her case, the committee finds that there is not sufficient evidence to hold the president accountable, then there is now a mechanism to deal with that. Now, the committee may decide to agree with that mechanism or not, but that was a proposal and we accommodated that. And that also speaks to this structure of proceedings, of why the president then testifies after that. The issue about virtual witnesses attending virtually, the only reasonable explanation I can give to that is that you might have a witness that sits on the other side of the world and would really want to testify. And there would be, the terms of reference would be so tightly drafted that this witness would be unable to be here. And so we have taken into consideration, we try to balance the two by saying that the committee must take cognizance of the fact that there might be members that would be or witnesses that would be otherwise be inaccessible to the committee if it were to be the insistence on a physical meeting. And therefore we allowed the possibility that there might be a virtual meeting, but then we put strict criteria also there, good cause shown, and the committee must agree. And we thought that was a perfect balance to put in place for a provision like that. But again, it's up for the committee to decide whether to keep it or not. It is our proposal. A proposal which, with respect, we found in the other inquiry other inquiries as well, and we have to look at precedent for when we develop these things, what worked and what didn't work. And we felt that was a clause that we think might work. But if the committee feels it's not doable, then it's something that we can remove. I just want to check with my colleague. I think she will deal with the rest of the questions. Thank you, Chair. I hand over to Suan.
Thank you, Suan.
Thank you, Chair. Chair, with regard to the issue of the president not being allowed to call a witness whose evidence was previously presented by the evidence leader, Chair, the reason for such a clause is that the president or his representative will be given an opportunity to put questions to that person who has been called by the evidence leaders. So that is more a process issue that to call a witness again. However, if there is an instance where there is compelling reasons for that person to be called again, there is room for, in terms of the applications, for the president's representative to make an application to the committee, substantiating why the witness needs to be called again. Maybe the person did not address certain matters or certain new information came to light. So it's possible for an application to be brought, but if members require that provision to be made clearer or strengthened, then that's something we will consider. And obviously, once we receive their written proposals, we will try to incorporate those comments into the document. With regard to the question of opening remarks, as my colleague explained, it was more of a process issue as to how the inquiry would take place. So in the instance of the evidence, the chairperson starting with opening remarks, that's merely to commence the inquiry, and then the evidence leader being given an opportunity to start so-called presenting their side of the case. If the members feel that the president at that stage should be given at least the option of making an opening remark if they do want to, then we can also build that into the terms of reference. Currently, the president or his representative will make opening remarks when the evidence is presented, when the evidence leader presents all the evidence that they required or want to present, then the president can now be put to his case and he will make an opening remark. But if the members feel that that order is should be changed, then we will take that proposal into consideration once we receive the written comment and the committee decides that that would be a more appropriate process to follow. I do note the comment about the time. My colleague also commented on that. Those are very difficult questions as to how to balance ensuring the fairness to all the parties, and that there's also due regard to the time that we take to conduct the inquiries. We've incorporated members' proposals, but the committee will make the final decision as to what is the appropriate time to be allocated for each step of the questioning. And with regard to the venue, I think that is a issue that the committee will have to liaise with the administration regarding whether the venue can be secured or a specific venue can be secured or not. And if there is some agreement that would be incorporated into the terms of reference. I think I've covered all the questions from question, unless there's something else you wish for us to address.
Thank you very much, Michael and Suan. Thanks for those responses. Honorable members, as indicated, that the document will not be put up for adoption today. It's going to the parties to then make those final tweaks as we move closer to having our terms of reference, so that we can proceed. And I've looked at my diary, and I would like that we have a session. I know that it will be the constituency period, that we have a session on Tuesday, the 1st of September, to then go through the terms of reference and anything else that will have developed at the time. So that I think that will give the political parties adequate time to consider the semi-final terms of reference, and then we need to move closer to finalizing, and if there are aspects that are not finalized, we might very well have to evoke Section 13, wherein we use 13.1 for things that will then develop as we proceed. Can we accept that the document goes to the members and the political parties, and that it will be considered at our next meeting, which will be on the 1st of September, spring day, and then we'll all be jovial on the day as we move closer to finalizing the terms of the reference. Is there any objection to us giving the document to the parties, and that we then move closer at the next meeting? Honorable Maimane.
Thank you, Chairperson. Quick question. I just want to get clarity on your proposal. If meeting on the 1st, what deadline would you set for parties to make submissions in terms of, if any, additional input textually, so that we don't invest that meeting discussing, if you like, we can discuss submitted input. So I'm asking whether, is there a particular deadline for that? And your preference for Tuesday as opposed to Wednesday, is there a reason for that? We've typically met on a Wednesday. Is there a reason why you are suggesting a Tuesday, regardless of whether it's constituency period or not? I just want to understand your rationale on that issue.
Thanks very much. Thanks very much, Honorable Maimane, and thanks for that. I think that assist. If we can, so I'll tell you why I would like us to meet on the 1st and not on Wednesday the 2nd. Is because on Wednesday the 2nd, there's the review application at the Western Cape High Court. It's important that when we are meeting, we are fully in the meeting, and that not have one eye on the arguments that are presented in court on the 2nd of September. So that's why I'm having the meeting a day earlier, so that those that might wish, and obviously there's an interest from this committee on the proceedings of the 2nd of September, that those that wish to be present on the 2nd of September can be at the Western Cape High Court, where the review application will be heard. But in terms of the suggestion, which I take, I think it will be fair that we can have the return submission. We give it 7 days. We can have the return submission until Wednesday next week, and then those will then be collated and sent to members in preparation for a meeting on the 1st of September. So 7 days to the members for return submission, and then those return submission will be circulated to all the members, so that by the 1st of September we are not starting with a document and everyone is making inputs from on the day. I think that's a fair addition to the proposal. Can we agree on return submission by Wednesday next week, and then we have our meeting on the 1st of September to then move closer to finalizing the terms of reference? I see thumbs up, and I don't see anyone with a thumbs down. So we take that as a decision of the committee. So can we please have the return submission next week, Wednesday, and then we'll meet on the 1st of September, Tuesday, the 1st of September, a day before the review application at the Western Cape High Court. Thank you very much. Thank you very much, members. Can we go to the final item of the day? Today we are well within time. We're scheduled to finish at 12:45, and we will finish by 12:45. Temikos, can you take us through the minutes of the last meeting?
Good afternoon, Chair. Thank you very much. I hope you can see the minutes on the screen.
I can see them, Temikos.
Thank you, Chair. As indicated, Chair, the minutes of the 5th of August. We had 5 agenda items, consideration of and adoption of recommended evidence leader, briefing by CLO on the President's appearance, draft terms of reference, and also consideration and adoption of minutes. The first 3 pages, the attendance of members and officials, and then is the welcoming and introduction, the apologies, the consideration and adoption of the recommended evidence leader, as well as the briefing by the CLSO on the appearance of the President. And then it was the consideration of the draft terms of reference, the consideration of minutes, and the resolutions. Quickly, the first one was the recommendation of the appointment of Advocate Madonsela, and the second one was the ruling chairperson on the matter between Mr. Dagmo and Mr. Malema, as well as the third one, which really just speaks to when the committee was scheduled to meet and to also afford time to the CLSO to complete the administrative processes that were relating to the appointment of the chief evidence leader and also finalization of the draft terms of reference. So, Chair, those were the minutes, and perhaps should take note of Resolution B that speaks to the ruling that you had to make. Thank you very much, Chair.
Thanks very much, Temikosi. First, we'll just check the corrections of the minutes. Are there any corrections? I see Honorable Dagmo.
I'm sorry, apologies, Chair. No, it wasn't a correction. It was just broadly a matter arising, but it's not a very big point. But no, I think the minutes are an accurate reflection of the discussion.
All right, thanks very much. So there's no correction. Can we move to accept the minutes as they are, as a true reflection of our last meeting? Any mover? Honorable Dagmo, I'm moving for the adoption of the minutes.
Yes, Chair, I do. I move for adoption of the minutes.
All right, thanks very much. Can we get a seconder?
I second the move for the adoption of the agenda, the minutes.
Thank you very much, Honorable Mahlaule. So the minutes have been accepted as a true reflection. Honorable Dagmo, you wanted to raise a matter arising from the minutes?
Thanks, Chair. I think it's an indirect matter, given the broader discussion in the minutes, but I just want to put on record to thank Honorable Zungula that he didn't bring a request to this committee to join his appeal. Thank you.
That's not a matter arising. That's not a matter arising, Honorable Dagmo. Please don't try to delay the meeting. Honorable Mahlaule, is it a matter arising?
Yes, Chair. If you recall, it's reflected in the minutes, the issue of withdrawal of the statements made by Honorable Malema and Honorable Dagmo. You said you will look for a ruling and give a ruling at a later stage. I'm not sure whether this is the later stage or there will be another later stage. Thank you very much.
Thanks very much, Honorable Mahlaule. So it's a matter that I'm going to go to now. So I have sought advice, also getting the transcript of what was said in the meeting, and want to first check if Honorable Malema is available in the meeting. Is still logged on.
Chairperson, from our side, Mr. Malema had logged on earlier, but he's not in the platform currently. Thank you, Chair.
So Honorable Malema is not on the platform, so it's important that when I give this ruling, is on the platform, as it is ordinarily the case when there are matters of this nature. So we'll wait for the next meeting when he is on the call, and we'll deliver the advice that we have received. So it's, as we'll know, even in the National Assembly, when there are issues as it relates to the rulings, it's important that the members that are affected by that ruling are in attendance before a ruling is delivered. It's never delivered in absentia. So we have the ruling, Honorable Matlaule and honorable members. It will be delivered when both Honorable Malema and Honorable Dagmo are in attendance. Honorable members, this concludes our meeting. I want to thank yourselves for this meeting that has taken the decisions that it has taken as it relates to the letter that we received from the president. That letter will go to the legal services to give us advice and the options that are available to us. And once that advice is received, it will be shared with the members. The second one is that we have received the draft terms of reference that were presented by the legal services, and we are giving it back to yourselves to then look at them, provide written comments by next week, Wednesday, the 26th of August at 1600 hours. If you can provide the written submissions so that when we meet on the 1st of September, on Tuesday, the 1st of September, we can have circulated the draft submission to all members so that we move closer to finalizing the terms of reference. So thank you very much for attending the meeting. Thank you to the support staff members. Thanks to members of the media who broadcast the sitting of this committee, and everyone else who follows the work of the impeachment committee for Section 89 on the parliamentary YouTube channel and other social media platforms. We thank you very much, and have a great day, and enjoy the question session that will start at 3 o'clock this afternoon. Have a good day. Thank you very much.
Thank you. Bye-bye.